Don't go in the car. Do not go in the car. Don't go in the car. Walk backwards towards me. Walk back towards me with your hands in the air. Put your hands on the car. Put your hands on the car.
I ain't doing nothing.
Stop.
Or do nothing.
Stop running. Stop running.
Move. Okay.
No. Put your hands behind your back.
No.
Put your hands behind your back. You're being
What I
detained.
do? What I do?
You're being detained.
What I do? What I do?
You're being detained.
What I do? What I do? What I do? What I do?
Put your hands behind your back. You're being
Why?
detained.
Why?
For investigation.
Why? Why
Because
though?
we were told
Why?
that someone had a gun.
Why?
Okay?
Nobody don't got no
Hand
gun.
Are you going to calm down?
On November 13, 2024, at a city and state not verified by the supplied record, officers conducted a high-risk vehicle detention after a report involving a possible gun. The record supports one reported weapon allegation and one arrest. The real issue is not the driver's attitude, it's whether each police intrusion had a lawful basis.
Stop running. Stop running.
You about to say
Like
this
somebody wasn't running fast enough.
You about to say this again.
I was doing like, right.
You want to walk up on him or wave? Driver, turn off the vehicle. Put your hands outside. Open the door from the outside, okay? No, you don't. We'll explain everything to you. Listen to my commands, okay? Open the door from the outside. Show me your hands. Put your hands in the air. Okay, put your hands in the air. Put your hands in the air. Walk backwards towards me with your hands in the air. Walk backwards towards me with your hands in the air. Walk back, so are we. Walk backwards towards me with your hands in the air. I'll explain everything to you once you come back to me. Don't go in the car. Do not go in the car. Don't go in the car. Walk backwards towards me. Walk back towards me with your hands in the air. Put your hands on the car. Put your hands on the car.
I ain't doing nothing.
Stop.
Or do nothing.
What are you doing? What are you
Stop running. Stop running.
Move. Okay.
No. Put your hands behind your back.
No.
Put your
Why?
hands behind
Why?
your back. You're being
What I
detained.
do? What I do?
You're being detained.
What I do? What I do?
You're being detained.
What I do? What I do? What I do? What I do?
Put your hands
What
behind
I
your
do?
back.
Do what I do? So like cause for what though?
You're being
Why?
detained.
Why?
For investigation.
Why? Why
Because
though?
we were told
Why?
that someone had a gun.
Why?
Okay?
Nobody don't got
You
no
want to
f***ing
stand
gun.
up?
You
Are you going to calm down?
Yeah.
Okay.
Do I? You
I'm
scared?
fine. You want to stand up with me?
Are you scared?
Here.
Okay. Thank you.
Okay.
Yeah.
I'll leave those on the ground. Stand up with me.
Right.
your knees
you
close to
scary
you.
ass motherfucker. Got a f***ing
Put
gun.
your knees
But
towards-
y'all don't got no search warrant. But no f***ing search warrant though.
Stand up.
You know,
Stand up. Do you want to stand up or no?
duh.
Okay, come on.
How I gonna stand
Stand up with me.
Right. Auntie y'all smell like a bubble just. Yeah. Why y'all like got me arrested? Somebody had a gun. She
Come on.
say scary as.
Come on.
Yeah. Yeah. Then like a whole female shit. Why I ain't called like a female cop? Shit.
problem would have been solved.
Right. Are you checked the car yet?
No, look, Whitney.
We didn't have the chance.
Whitney.
Okay, I'll calm down.
Whitney.
Okay, I'll calm.
I gave him my key and a weapon in the car.
I know.
I gave him
know
my key.
that, but what the f they put?
Someone say
then
there
what the
was?
f I'm in handcuffs
I
for?
told them in the hospital, yeah.
Right.
I'm
Scary ass.
scared of yourself.
Scary.
For real.
You can't
Scary
bring
ass mother.
I never even walked in the hospital with a gun. What are you talking about?
Ain't shit happening.
Near the turning point, Terry versus Ohio supplies the first rule. Officers may briefly detain a person when specific and articulable facts create reasonable suspicion of criminal activity. A protective frisk requires reasonable grounds to believe the person is armed and dangerous. Here, the reported gun could matter, but only if the information behind that report was sufficiently reliable. While a gun report raises obvious safety concerns, the word gun does not erase the Fourth Amendment. Courts still examine what officers actually knew, how specific the report was, and whether it matched the person detained. The transcript does not reveal the caller's reliability or the dispatch details, so the initial justification cannot be fully tested. Still, police do not have to ignore a credible threat while they investigate. Terry versus Ohio permits a limited detention when objective facts justify it. The counterargument is that an allegation cannot become automatic proof. That leaves the next legal issue: how much control officers may exercise after a vehicle has been lawfully detained.
Damn. Y'all doing that for? Then I'm a f***ing woman it too. What?
Come on.
Hey, Whitney, relax.
Damn. Let's do this. Scary ass mother. Wow. Scary. Wow. Damn, I don't got no balls. Just got one. Yeah. So like a hand.
Take a seat.
Yeah. Take a seat for what?
You're being detained, like I told you.
Right.
What's that?
Watch my motherfucking head next time. I ain't stuck the same.
I
Yeah,
expect
come on.
you to be laying back here.
Yeah, come on.
All right, come on up.
Boy, that devil.
We were just cool 2 seconds ago. What
I don't
happened?
get no. Yeah.
Okay.
Right. Do I have devil?
This one right over here, okay?
White shit. You bracelet. Yeah. What I do?
If you want to turn around and then,
Alright.
if you turn around and sit down and then kind of slide in, it's a little bit easier.
What? You like to handcuff me?
No, if you turn around and face us and then sit down and slide in, it's easier to
Face
get
size
in.
is what it is. What the devil? Yeah. So I can't wait.
Thank you very much.
Bible.
All right, ma'am.
We're gonna
We need
step
to
out.
step out so she can search you, okay?
Why? And for what? Do what I do.
I don't know, ma'am. Somebody placed
Do what the
it
f y'all
in
like or
custody.
ain't doing y'all job and let know y'all ain't know.
Okay, I'm here to search you because I'm a
Okay.
female. You're
Why?
under arrest
Why
at this
though?
point.
Why though?
Do you want?
Why?
What do you mean why?
Why? Why I'm arrested?
Do you want me to figure out for you?
Yeah, like
You're
come
not gonna
back.
let me-
Yep, I ain't come back. Yeah, back.
Okay. Is there a snake in your boot?
Oh, maybe not.
Oh, it's just maybe loose.
You're under arrest for obstructing and resisting.
What? Oh, because
Okay.
like I know somebody was
All right, I need to search
Right.
you. So get out of the car.
shit. I don't give no f about that. Cause y'all was that's why. Shit.
Okay, face that way.
Do hurry up.
All right, face the car. Do
Uh-huh.
you have anything on you?
No, nah. Just these motherfuckers. Right. I don't know.
You about to say
Like
this?
somebody wasn't running fast
You-
enough.
you about to say this is hands,
I was
right?
doing like,
All right.
right.
Yeah, you are.
Yeah, I'm like, good there. I'm like, yeah. I'm like, he is here. Right. But when they gonna take me to jail? Man, like, hurry up, buy me the f out.
After you search.
Yeah, when?
She's
I'm
searching you right now.
Hurry up, like, buy me the f out.
She's searching you right
whatever, I
now.
got to bond, whatever, so, whatever. I'm gonna, because I'm gonna be out of jail and shit like today. Yeah. Okay. Alright. The white devils.
We're gonna get your seatbelt in, okay? Make sure you're safe.
Okay, well, hurry up. You know, like Uncle Tom and here you go.
Lindsay? What? Are you gonna take it off? I'm just looking at it.
Okay, well, this is motherfucking weed.
Yeah.
Like you get, like all that. Yeah. So, like, hurry up, like, take me to the things. I'll get this shit over so I can be, it's another time for this. This voice. The white devils. I can wait till I'm on the Bible.
Pennsylvania versus Mims holds that after a vehicle is lawfully detained for a traffic violation, officers may order the driver out without violating the Fourth Amendment. The Supreme Court treated that added intrusion as minimal compared with officer safety interests, but Mims does not independently validate the reason for the original stop. While Mims gives officers substantial control over a driver's location during a lawful stop, it cannot repair an unlawful detention that came first. The transcript does not disclose the complete basis for the initial seizure. That missing foundation matters because every later safety command still depends on lawful police authority. Terry versus Ohio also separates a protective frisk from a general evidentiary search. A frisk is tied to immediate safety and requires reasonable grounds to believe the person may be armed and dangerous. A reported firearm can support that concern, but its weight depends on the source specificity and reliability of the information officers received. That said, the Fourth Amendment does not require a warrant for every police search. Terry versus Ohio recognizes a narrow protective frisk without a warrant when its standard is met. Other warrant exceptions may exist, but the transcript does not provide enough verified facts to select one or to conclude that every search discussed fell within a valid exception. Illinois versus Wardlow adds that unprovoked headlong flight can be relevant to reasonable suspicion because evasive behavior may suggest wrongdoing. But Wardlow does not make running automatic proof of a crime. While flight can strengthen suspicion, innocent explanations can exist, and the conduct must be assessed with all surrounding circumstances. A separate Fourth Amendment question concerns arrest. An arrest generally requires probable cause, a stronger standard than reasonable suspicion. The transcript uses the phrase obstructing and resisting, but the state is unknown. Without a verified jurisdiction, no responsible analysis can assign a state statute number or claim that specific statutory elements were satisfied. That limitation matters because resisting and obstruction laws differ by state in wording, intent, and the significance of lawful police authority. While the conduct described may support an arrest somewhere, the exact charge cannot be tested without the governing statute and reliable facts establishing what legal duty applied. Verbal disagreement also must be separated from physical conduct. Asking why a person is detained or objecting to police action does not by itself justify treating speech as resistance. Still, verbal protest does not create a right to physically defeat a lawful detention. The legal line depends on conduct, lawful authority, and the elements of the applicable law. The officer's response reflects a recognizable safety rationale. If the gun report was credible, controlling the driver's position and access to the vehicle could reduce the risk of an unseen weapon. Still, safety measures must remain connected to lawful authority. Missing dispatch facts and the unknown jurisdiction prevent a complete legal endorsement of the encounter. The driver's response created separate legal and safety concerns. Challenging police authority verbally is different from physically evading a lawful detention. Flight can increase danger and strengthen suspicion under Illinois versus Wardlow. Still, its legal consequences depend on whether the detention and commands were lawful under the facts known to officers at that moment. First lesson: personal rights are usually protected more effectively through clear verbal objections than physical resistance or flight. If an order appears unlawful, compliance under protest followed by legal review is generally safer than forcing a constitutional dispute to be resolved during a fast-moving roadside encounter. Second lesson: officer safety does not replace constitutional analysis. Terry versus Ohio and Pennsylvania versus Mims give police meaningful tools during lawful encounters, but those tools have boundaries. Agencies protect officers and the public when detention grounds, dispatch information safety commands, and search justifications are clearly documented. Third lesson: jurisdiction controls the charging analysis. A phrase like obstructing and resisting cannot be mapped to a statute until the state is verified. Accurate review requires the actual jurisdiction, charging language, and facts supporting each element. Guessing a statute may sound confident, but it can make the analysis legally wrong. This incident shows why Bodycam review must separate safety concerns from legal authority and suspicion from proof. The verified record supports analysis under the Fourth Amendment, Terry versus Ohio, Pennsylvania versus Mims, and Illinois versus Wardlow. Claims beyond that should wait for the missing jurisdiction and primary records. Thanks for watching.